Hi, my name is David Leichtman, and today we're going to be talking about the protection of computer software, whether through intellectual property, contract, or employment agreements. After spending over 20 years at large law firms, in 2017 I started a small law firm with 6 lawyers to represent companies in the trial of complex business and intellectual property disputes. With us today, we have Larry Miller and David Horowitz, and they're each going to briefly introduce themselves now.
Hi, my name is Larry Miller. I'm presently Senior Managing Counsel at BNY Mellon, a large custodial bank in New York. My practice is a largely transactional practice with software licensing, application service agreements, that kind of thing. As well, I oversee the prosecution of our patent applications and advise litigation counsel in connection with the defense of patent litigation. And the most fun that I have is engaging in blockchain development for the bank.
I'm David Horowitz. I'm managing partner of Luminary Experts. We are a software research and litigation service and expert witness agency. And I've been a software consultant and vice president of Soundside Inc. for several decades and have performed a wide array of software consulting services for a wide array of clients in many different industries over the years.
All right, so we're going to start by just doing a little bit of an overview of the manner in which computer software is protected by intellectual property or contract. And let's start with a discussion of when one might try to protect computer software with a patent as compared to a copyright or as compared to a trade secret. But just for a little bit of background, Larry, can you tell us a little bit about how the legal function interacts with the computer coders at Bank of New York Mellon, and how many, starting with how many there are, and exactly what your function is with regard to computer software?
Yes, so out of about 50,000 employees, we have about 6,000 developers internally developing code. For the most part, the code they write is used internally by the bank for the benefit of customers. There's a small amount that gets licensed outside, but for the most part, it's used in transacting business for customers. The interaction with the developers takes place at several different altitudes. At a very high level, there's an impact that takes place at the corporate and the holding company level in terms of setting policy under the living will of the bank that is established as required by the Fed. And we recently made a determination that we had to be sure that all of the software that was internally produced was either owned by or licensed to the particular operating units that were using it. Given that we have a 14-page corporate org chart, that was a major undertaking to get organized. The other side of the coin, down at the more micro level, is I'm on a group called the Select Counsel that is the internal governance body that governs the use of open source software by the internal development group, and also oversees the outbound licensing of FOSS developed either corporately or by individual developers that they want to contribute. So it happens sort of at both ends.
Okay, good. And David, can you, again, just for context, give us an idea of the types of cases you've been consulting on or acting as an expert witness on, again, just for context for our audience so they can understand some of the context for your remarks that you'll make later?
Sure. So with my technology background, I've been able to assess the situation on various cases regarding copyright infringement, patent infringement, trade secret misappropriation. Haven't really done much trademark work because it doesn't really specifically apply to software coding per se. So I've been involved in cases, I've testified in cases where one company has developed some software and there's been disputes over another company that seems to have copied the code which would have infringed their copyright. I've had other cases where the obvious patent infringement allegations where it looks like a company's implementing somebody else's patent. Also I've been involved with trade secret cases where the plaintiff asserts that they have ownership of certain trade secrets that they believe that the defendant is utilizing without their permission. And so that's all in the domain of intellectual property, but I've also gotten involved in contract dispute cases where one company is suing another for either non-performance of software development services, or one company is suing the other for not paying them for performing the software development services. And so often there's an analysis that I need to perform to see what was actually contracted, what was actually delivered, and who paid or who didn't pay, and why that happened.
Okay, good. Now, Larry, sticking sort of with the background issues, can you talk a little bit about the process by which the bank or any big company should be thinking about when it decides, with particular regard to computer software, whether to file for a patent, to register a copyright in the code, or instead to keep the code as a trade secret and not file for intellectual property protection?
Sure. So it really is a matter of keeping as many strings on your bow as you can, as late as you can in the game. At some point, if dispute resolution is taking place, you're going to have to make an election. But prior to that election, you want to have as much available to you as you possibly can. So typically, you keep things confidential, software, but anything confidential, unless there's a reason to disclose it. And the open source context is the obvious example of deciding you're going to disclose something that you've developed that you could have kept proprietary. The other thing is to recognize from a copyright point of view that all of the code that's developed is copyrightable subject matter, and copyright attaches from the moment of creation. So without registration, you don't need to take any steps to have copyright attach. And then if an infringement of copyright occurs, you have to have a registration as a condition to filing a suit, but you can make that election at a later time. And then the trade-off between patent and trade secret is once a patent application publishes, whatever is disclosed in there is now public and clearly doesn't qualify for trade secret status. So in a relatively small category of cases, you'll have a decision to make at an earlier time. Am I going to keep this as a potential trade secret, or am I going to file a provisional patent application on it and start a prosecution with respect to it? The trade secret status of anything software flavored in general, these days, most people, well, I shouldn't say most people, we tend not to regard very much as something we want to keep as a trade secret. In terms of the actual proprietary status and the benefit of keeping it really confidential, that constitutes a shift. If you were to go back to any arbitrary period like the 60s or the 70s, trade secret protection was a really major thing in terms of the way that licensors approached the market. And for us, as someone who's not actually making the code itself available outside the institution, you don't have to do much. You don't, with respect to the trade secret aspect of things, but you don't have to also say, I'm going to silo my developers. The old-fashioned way would be to silo all the developers. You've got magnetic card readers, and if you're not in this group, you can't enter this room. That's generally not the approach today, and to a large degree, that's because of the influence of the open source movement And really, a lot of development houses are much more free-form and much more encouraging among the internal development group of sharing ideas, which wouldn't have been done in the past.
Okay, good. And for those at smaller companies that may not have all of the same resources that a big company like the bank has, is there some rule of thumb that they can consider following about what is the right time to file for intellectual property and perhaps give up those secrets that they might be holding in their code?
I guess I'd say keep things generally confidential from the outside world. Recognize that copyright attaches from the moment of creation, and then make that election between trade secret or not at the latest possible time, so long as you're keeping a generally clean kind of housekeeping internally on how you govern your personnel and your development activity.
Great. And what I would add to what Larry said is that there are certain remedies under the Copyright Act that you have to have registered for in order to get those remedies before the infringement began. So if you wait for an infringement and then you file to register, you would be giving up remedies to statutory damages, which are up to $150,000, and to attorney's fees if you win the case, but attorney's fees are not mandatory, they're discretionary in any event. So most of the time when you're talking about very large scale products, the damages for an infringement are going to be greater than $150,000 anyway, so the statutory damages are not an issue, but you would be giving up your potential for recovering attorney's fees if you wait to register until after you recognize an infringement. David, what are some best practices that you would recommend that can help a company establish the provenance of where different pieces of code come from in a computer program?
Yeah, well, I think it's reasonable to assume that you may have a problem down the line, that there may be some infringement. If you have a product of value, I think it's reasonable to assume that you'll have somebody stealing your intellectual property at some point. And I truly believe that it's very hard to physically prevent it from happening. You can take as many steps as you can to make it harder, but I think the best thing that you could do is, knowing that it is possible or likely that there will be some issue in the future down the road, if you plan from the beginning to establish your ownership of your product with the most thorough and complete documentation that you can possibly imagine, which would be everything from internal code. It would be stuff specifically related to the software, internal to the software, such as code comments, and then there's design specification documents, functional specification documents. All that material should be really documented and locked up in a historical record that establishes your provenance to your software. Somebody can always delete, if they copy your source code, they can always delete your copyright. So it doesn't always mean that much, but you should just do it as a matter of practice. And I always recommend, and I always do this myself, at the top of every source code file, I always have a header block that's maybe 20 lines long, and it identifies everything that I can identify about that one file. So it's the name of the company, the name of the project, the name of the, maybe the retail name of the software, the date that this particular file was created, the name of the person that created the file, maybe a physical location where this occurred. And then in every source code every source code file, I establish a modification trail, which would mean that every single time somebody changes the source code, they're actually writing a little comment right there in the source code, even though the source code control system should also maintain those sorts of records. Right there it lists who made the change, the date, and what it was, with a marker that is actually like a little, I use an @ sign with a sequential number, and then when I actually go make that code change in the code, I go and actually put a comment that refers to that, so you can cross-reference it to that particular change. Now, I think that's challenging to do that during the early stages of a software product's development, because there's so much change occurring so quickly. But once a product is relatively mature, I definitely do this. And I don't rely completely on the source code control systems, because even though they would maintain they do maintain an audit trail for you, it's not enough. And also, again, you're so dependent on every single developer. You know, is each developer going to maintain those practices or not? And that's why I think you really need a lot of oversight. You need a team manager who is really, and people will hate this person. It'll be the person that says, like, you know, hey, you know, I noticed you're not really commenting your code properly, and also when you checked in this file, you didn't put a comment about what change you made, and that's typical. But you really should be putting in a comment saying why you made that change, what the change was, and why you made it. I always think about who, what, when, where, why, and how. Who made the change? What was the change? Where in the code is it? Why did they make that change? You know, all that stuff. So.
And I can say, as the lawyer that then has to go try these cases, it certainly makes our job a lot easier if somebody has done that and followed those best practices than having to rely on things like what we call the dominant author test in copyright law now, or you know, other you know, kinds of proof problems relying on emails of this code was transmitted on this day, and look how similar this version looks to that version, and so on. So certainly from the standpoint of the trial lawyer, speaking to in-house lawyers about how you can convince the business people and technical people at your companies to do these best practices, it does make it a lot easier to establish the proof that we need at trial to show what one party's contribution was relative to the other, because a lot of these cases are not third-party strangers you know, to an infringement claim, but situations where somebody did leave a company, or there was, you know, a collaboration between two different companies, and then they had a disagreement or a business divorce or a technical divorce, and you have to unscramble the egg.
But I believe it would be great if the legal department was looking in, putting pressure on the development teams to say, you know, you really need to be doing this, and instructing them how to do it.
Okay, so if I can broadly state for our audience the difference between an innovation that might be patentable and code that might be copyrightable, I think to broadly state it, what would be patentable would be things that have utility and are functional, whereas functional elements are not copyrightable. What's copyrightable is the expressive features and aspects of a copyright software program. But how does the bank tell the difference when it's looking at one of its innovative, you know, computer programs? How do you make a determination? Yes, this piece of code or this program is patentable and we should pursue patent protection, or we should simply rely on copyright and trade secret for this other piece of programming?
Well, it involves involvement of counsel in the development process, and the sensitizing the developer community that if they come up with something really innovative and your boss agrees, hey, that's really hot stuff, I want to know about it, and that creates the opportunity for a dialogue to take place. Typically, it's got to be pretty significant, and since 2014, when the U.S. Supreme Court decided Alice Corporation, it can't be business methody. It's got to be nuts and bolts technology. It's got to be a technological innovation or an improvement on a technological method of doing things. Post-Alice, the implementation of a business method in a technological implementation, generally speaking, isn't enough. So it's going to have to be harder edged and really genuinely techier.
Okay, great. Well, now let's talk about a little bit about with the background that we have, how you deal with employees who are developing these products, and then we'll also discuss how you deal with some third parties. But first, with employees, do you just rely on a company policy document that things are meant to be secret, or do you have separate confidentiality or NDA agreements with your employees?
Both, and so the policy is a broad-scale employee code of conduct that includes provisions about ownership, copyright, and the assignment of individual inventorship to the company. And then there is an annual questionnaire in which each of the employees in the company is required to answer a sequence of about 60 questions about things that have happened to them in the last year, things they became aware of, and have you read and are you in compliance with the employee code of conduct, that kind of thing. In addition, at the commencement of employment, there is an employee confidentiality and inventor rights assignment agreement that they enter into. And so we're covering it both ways.
Okay, and with respect to those assignment documents, is there any magic language that companies need to use to make sure they're properly getting the rights?
Well, yes, because the assignment is attaching both to copyright as well as patent and trade secret rights. And the copyright in particular, the copyright arises at the moment of creation. And if you then focus on the patent side, there are inventorship rights, but they have to be assigned. Okay, so you have assignment language that is both as of the moment that the document is executed, plus forward-looking to the time of creation, and then an additional promise with respect to any subsequent perfection of those rights on behalf of the company, any filing that needs to be made, and then that the individual will enter into any documents necessary to perfect those rights.
That's right. And there's been, of course, case law that has said it's not enough to simply say, I will assign in the future. You have to say, I will assign and I hereby do assign.
I hereby do assign, yes.
And of course, that's a very difficult concept to understand when the invention hasn't been created yet. So do you then go back and have something like an invention disclosure document?
Well, so with respect to patent filings, number one, there is, of course, a disclosure document in order to begin the process of filing a patent application if it's patentable subject matter. But in addition, there's a separate fileable assignment that the patent office wants to see, and you have to give it to them in the form they want. So that's the final layer on top.
Okay. Now let's flip the script a little bit. Let's talk about new employees that come in that may have information and technical knowledge from their prior employers. What steps, if any, do you take to avoid either direct or inadvertent copying of a prior employer's work? For example, do you use software clean room approaches, or how do you sort of police that and make sure that your new employees are not doing something that they might be prohibited from doing under their agreements with their prior employer, whether express or implied? Larry, why don't we start with you?
Yeah, in our case, it's a matter of when an offer of employment has been made with respect to a developer, there's essentially a disclosure that's requested about agreements that they may have been a party to prior, in their prior employment, as well as inventions that they may have been involved in earlier. We want to know about it so that we can make sure that we're not running afoul of it. And that's basically a requirement that's enforced by the management of each of the developer teams.
And David, in your experience, what do companies do to try to ward off against potential claims coming against them with respect to new employees that they hire? Yeah,
especially with small companies, I think it's very important to know who you're working with. I guess that would be true for even large companies. It's so challenging because we're all busy, we're doing our work and we're doing what we're doing, but I think that you put yourself in the best position if you can really get to know everybody that you're working with. And I think that a team approach, and in the software industry these days, we're using a lot of things called agile development and XP development. And it's all about teams getting together and huddling every morning. And it's all about getting to really know what everybody else is working on. And the more that you can foster a team approach, and the more that you foster communication between the team, and also then you got to make sure that lines of communication are open external to the team. So I think it's really all about communication these days. And as Larry said, if you have interviews and documentation and disclosures when new employees come in, that's of course very important, but then also just to make sure that things are always being communicated throughout the whole life cycle of somebody's relationship with a company.
And what would be, if you were thinking about this from the standpoint of the claimant, what would be some of the markers that you might be looking for in pursuing a claim of copying or defending against one in that regard?
Well, with copying, you have to, of course, establish that the defendant had access to the code. So the first step, of course, is to be very cognizant of where your risk points are. Code that is internal to your own network is relatively safe, and then of course it's locked down, and any, generally enterprises above a certain size will have their whole network locked down. I know at the bank you can't put in, and everywhere else, you can't put in, if you put in a thumb drive into your computer, it won't work. You can't email documents outside of your office, etc. But even with that, there's, again, as I said earlier, I just feel it's almost impossible to guarantee that there won't be an exfiltration of your intellectual property going out of your network. So I think one thing would be to know who you're at risk from, because sometimes, or more often than not, the person that you need to be concerned about is the person that the ex-employee, or I've had cases where employees or managing partners of a certain company left to start their own company, and maybe they had access to the prior source code, and maybe they started this new company with access to the new source to the prior company's source code. So I think having an eye on who your likely risk factors may be is one thing. Another thing is to do what you can to make your code identifiable. It's very common in the software industry. We have this history of being Wild West hackers and rogue programmers and things. And so some people don't like the whole corporate identity and corporate culture, and they will resist documenting their code well. And that's going to be problematic for the company, because I would say that the more well-documented your code is, the easier it will be to prove that it was copied when you find that code existing in somebody else's code base. So Larry, for example, are there things that the bank does or requires that its coders do to establish the provenance of code, or techniques that they use to avoid these kinds of proof problems down the road? And what do you do to make sure those practices are followed on a consistent basis, if anything?
To be completely candid, I don't have a clue. So, that's the truth. I don't know what they do. I do know that they have a whole bunch of rigorous processes. I do know that our systems are locked down, and that they do document the code according to policy requirements. But beyond that, I really can't say.
Okay, good. Now, let's talk about sort of these lockdown procedures a little bit. Larry, can you just describe a little bit what the lockdown procedures are and how they work? And then we'll talk a little bit about what a smaller company might be able to do to replicate what bigger companies do in that regard.
Yeah, it's really, it's a combination of both policy as well as technology implementation. Just as an ordinary employee, I can't install software on my bank computer. I can't download anything to it. If I plug any external peripheral device into it, it doesn't work. When I'm working at home, I can't print. I'm in a bubble with that computer. From a policy point of view, the recognition is, if you're a developer, you have to do your development of the code on a bank computer. You can't do it on your own computer. You have to do it on the computer that's given to you by the bank that's controlled. Flip side of that is, if you're an employee who has applied and received permission to contribute open source software on an individual basis to an external computer, then the requirement there is you do it on your own computer and on your own time. And what that means is you've got separate computing islands that are intended not to communicate with each other. One has the individual development activity, the other has the corporate development activity, and they're not supposed to be able to communicate with each other.
How is that bubble, so-called bubble, created? What can a company do that maybe doesn't have the resources of the bank to configure their devices and their employees' machines in order to create this same kind of bubble without sort of breaking the resource bank, so to speak? David, do you want to speak to that about what smaller companies could do in that regard?
Well, clearly, I think it's a really large challenge these days because, okay, so if you're in a corporate environment where you own the network, well, you can create your firewalls and do something quite similar to what large institutions will do. And it doesn't have to break the bank. You can, every router in effect has a firewall in it, so it's not necessarily a problem in terms of feasibility. But then you got to widen your scope a little bit because these days there's so much teleworking going on, and you're always running this balance between letting your people be effective at what they're doing, but also protecting the interests of the company. So I know as a developer that having access to the internet and resource materials that are on the internet is very valuable and almost crucial to my development efforts. I do research continually whenever I'm developing code to check out best practices or see if there's some snippet of code available to see how to do something. I once heard somebody say that Google is an extension of our mind now, of our memory, that you don't have to remember anything anymore because it's all out there on the web. Well, that's pretty much the case. So, in the old days we used to pour through these reference books and all these things. Well, who needs a book anymore? It's all on the internet. So I think there's a practical consideration about if you're going to be working on a locked down environment, you're restricting your access to source materials. So, there's that concern, but so I think that small companies can implement it. It is feasible. Oh, however, I want to mention this. If you are working remotely, of course, as you do with the bank, you can have a VPN. So the company can institute a VPN, which means in effect that for people that don't know, it means that when you want to do anything with the corporate network, you have to first create a secure connection from your computer to the corporate environment. And that's called a virtual private network or VPN. And doing it that way, then you can have a lot better, give yourself a higher possibility of really preventing undesired sharing of data between unintended places. But it's still, my opinion is that while every institution will try to protect themselves as much as they can, and you can try as hard as you can, and you should, however, no matter what you do, I still think there's always going to be loopholes and backdoors and thefts and exfiltrations that happen, and infiltrations too.
Now, Larry, you had mentioned that the bank does use some open source code. And how does the bank make its determinations about whether it's going to use some third-party code or some third-party plug-in or something like that in connection with one of its internal products?
Sure. Well, there's several constituencies that have to weigh in on it. There is a architecture review board that determines whether it's permissible to bring in any code of any kind, period. And so open source is one of those things. Vendor-provided software is another thing, but it all goes through the architecture review board. The FOSS Council that I sit on is looking at two things. We have information security representatives who are identifying known vulnerabilities, and they may make a determination, no, this particular piece of code you can't have because of a known vulnerability, or you have to have release X.Y.Z or up because they've determined it's okay after that. They also perform a scan on all the code that comes in all the open source code that comes in, and determine whether, from the viewpoint of the scan, it's safe enough. And then what the lawyers on the FOSS Council are doing is reviewing the license compliance requirements to determine when we distribute this, and we take a very conservative view that distribution within the enterprise is distribution within the meaning of the software licenses that we're looking at. Then we have to say, okay, well, if it's going to a desktop, you have to have a text file that has the copyright notices, the license text, and the URL where the source code can be downloaded from, or whatever the compliance requirements of the particular license are. That way we feel confident that we're not going to be running afoul of either a technical non-compliance or there are actually some bad actors out there, if you will, who are offering software that's both open source and proprietary licensed for the purpose of saying, oh, you violated the open source license, you're going to have to now have an audit under the proprietary license, and it's going to be really expensive. So it's intended to avoid that too.
And in some cases, it could cause the publication of your own code.
Well, yes, if it's one of the copyleft licenses, that's entirely possible if you're modifying it. We also have a requirement that if you come into the FOSS Council for leave to incorporate software in something you're working on, step one is we say, okay, but if you want to modify it, you have to come back. We have to know exactly what you're going to be modifying it to do, what the circumstances are. We will define what the license compliance requirements are for the modification, because under those copyleft licenses, that creates the risk that the source code may have to be contributed back to the community. Obviously, you can't have it be proprietary if you have to contribute it. So that choice has to be carefully monitored.
So it sounds like there's a role on this committee for both legal representatives of the company, business representatives, and technical representatives.
And then the Architecture Review Board is a separate organ, and they are doing all their stuff too.
All right, and David, what have you seen in terms of practices, maybe at smaller companies that don't necessarily have all of those interests represented on a equivalent council?
Well, it's good to be aware of them, for sure. As a software developer, I think that it's very common that we want to utilize occasionally third-party tools, whether they're open source or commercial. It's a simple case of you don't always want to have to reinvent the wheel. You can force yourself so that you just don't have any dependency on any third-party products, but that's a practical limitation. It's very common that we want to use a third-party tool, and I think you need to be very cautious about what are the implications for you if you're going to be modifying open source code under a copyleft license, and then now you got yourself stuck in a situation. Typically, I don't come across that too much. I prefer, actually, personally, I prefer to use third-party tool sets that are just a black box, so that you don't, the license is really clean, you don't have to worry about it, and you don't have access necessarily to the source code, or if you do modify it, you have a commercial license to it. I'm not quite as experienced with the different ramifications with different types of open source licenses, but I think it's really important to be careful about that, whether you are a large enterprise or a small one.
Well, maybe it's a good segue into the special case of blockchain, which is on everybody's mind these days. And cryptocurrency, of course, is a sort of subset of blockchain technologies. But Larry, can you talk a little bit about the collaborative nature of how blockchain is being developed, and what a company like the bank that would normally keep its technology proprietary might be doing to participate in the development of the standards in the blockchain area?
Sure. I guess I would start just by picking up where you were 2 minutes ago. There is a business model choice about platform development and how proprietary you want it to be versus how much adoption you want to create by the outside world. And something that's completely proprietary is, to use your phrase of a black box, a potential user says, I don't know what's in the box, all right? And when you have an open source approach to the market, like the Red Hat model, for example, lots of different people write Linux, but the Red Hat version of Linux, their business model is you can have the software for free, but if you buy a maintenance contract from us, you get our official version and you get our support. That's a model that has gotten legs in the marketplace, and it applies as well to the development of blockchain platforms. So I think that in terms of the platforms that are available to us today, from R3, from IBM Hyperledger, from Ethereum, Enterprise Ethereum Alliance, those are all open sourced. And they've done that to increase adoption and increase collaboration and increase the degree to which development communities can grow and thrive, in which multiple different kinds of applications are being built by completely independent teams who have nothing to do with each other. Contrast that with, I won't mention names, but there's one company that I can think of off the top of my head in the blockchain space that has taken a proprietary development approach. And the consequence of that has been, if you then decide to do some development work that involves their platform, you now have to do a bunch of due diligence. And the technical people in my bank, when we were talking about which one are you going to use, whenever that subject came up, they said, yeah, now we got a lot of homework we wouldn't otherwise have to do, because the adoption by the entire world of the other platforms has created a lot of visibility, a lot of transparency, and a lot of development around it. So it's different ways to go. You can make your own choices. People make different choices, but they have different consequences, and they're really interesting to watch play out.
And so is that something we can expect to see from banks and financial institutions, their own innovations in connection with blockchain technologies?
Oh, absolutely. So just sticking in particular with banks, when banks feel either excited or threatened by technological development, they tend to form consortia. They're being defensive and being offensive. They're creating what potentially will become new businesses, and they're also making sure that they have a seat at the table, that they have a voice in what the development is going to be. So there's lots of bank consortia that have formed and are working on various different developments. BNY Mellon is in several of them. Truly, almost all the banks you could name are in them. And they are developing not the underlying platform, they're developing the applications that leverage those platforms, because what the banks do, they move money. They engage in business transactions of various kinds. What the blockchain offers is the ability to keep records in a different way, and to keep records in a way that's both immutable and avoids the necessity for duplication of records. In the conventional world, if you're my institutional customer, I have a ledger and you have a ledger. And the business that we conduct, that we transact between us, goes along. Sooner or later, those ledgers will differ. At least one of them is wrong, maybe both of them. But now you have to go through a manual reconciliation effort. The blockchain deployment eliminates that, because you have one golden record for whatever the community of activity is that's going on. So you've got some kind of trading activity happening. One golden record for all the customers. It's dramatically more efficient, faster, saves costs. It is in the process of revolutionizing financial services.
And so does that, do those developments impact the bank's view of whether or not it should keep certain technology proprietary or license out its technology?
Absolutely. It creates a whole new playing field. And often as not, now because you're in a consortium environment, you've got 8 other banks that have to be consulted on this. And it creates an awful lot of talk. I mean, there's a lot of things that have to get decided among all these different players, and you can slice that cake as many different ways as you can think about it. And it's really a matter of what business opportunity do these institutions feel they're pursuing, and how do they want to pursue it? Do they want to create an industry utility? Do they want to pursue it as a proprietary thing? Do they want to simply share ideas and go off and do their own things? It's a very broad continuum, lots of different things happening.
So the question is, when you have a situation like that, how do you address issues of joint authorship, and then subsequent to that, what flows from that as ownership or issues of co-inventorship?
It gets down to a very specific situation, all right? And I'll give you an abstract description of a concrete thing that's happening right now. A consortium in which it hasn't yet passed the go, no-go decision. They're developing, they're doing all kinds of things. And at this stage, the intellectual property ownership regime is all of the members of the consortium jointly own the IP. When the go, no-go decision is passed in favor of go, a legal entity will be formed, and the members of the consortium have already agreed in advance that they're all assigning the IP into the utility. And the utility is going to own it, the utility is going to operate it, and the financial participation will come through ownership in the utility. That's one way to go, but there's any number of different ways you can slice that.
And David, from your perspective, if it is desirable in that kind of situation for each entity to mark their territory, so to speak, with what each one contributed to the intellectual property to deal with disputes that may come up later about who owns what are some things companies can do in order to make clear what their contribution was to jointly owned intellectual property?
Well, the parties need to be very clear about what their agreements are with each other, because if they are going in jointly as equal members of a consortium, for example, then, and if the consortium owns the software, then I guess there is no independent identity to who's making the independent contributions. Do you know?
Well, so I don't want to get too far down into the weeds of the example, but in this particular example, there's two flavors of intellectual property. There's the tech stack and the business logic. The thing that I just described applies only to the business logic. The tech stack is owned by a technology provider that's under contract to the consortium. And so the software is all in the tech stack. There is, the question of potentially patentable subject matter in the business logic and how that's all going to shake out. As an abstract matter, joint ownership, particularly of patents with respect to multiple parties, is a bad idea. Okay, you have to have all of the patent owners have to get together to do anything in terms of licensing or litigation. It's a very awkward 3 or 8 or 12-legged race. I mean, it's just crazy. But in this particular case, it was chosen because that's the regime before the go, no-go decision. It allows everyone to say at any given time, I'm out of here. Okay, so there you're prioritizing freedom of operation if you run away.
Right, and I guess that's what I'm asking David about, which is if you have that situation where there's a divorce, so to speak, at some point, how does each party get to take their toys and bring them back home? How do you unscramble the egg, so to speak, and create that, I think you called it earlier, an audit trail of who brought what to the party and how they get to separate that out and take back what each owns back home with them?
And I want to understand better, when there is a consortium, is the consortium itself a legal entity?
Well, it depends. Again, it depends, okay? In the example I'm giving you, it's not, okay? Something else I'm aware of is a situation where a number of parties are getting together to collaborate, and it's even looser than that. I mean, I would characterize the example I just gave you as one where it's an unincorporated association, okay? In this other example I'm talking about, it's a bunch of different companies that are different participants in different parts of the the business landscape with some clients. The clients consume the services. The providers of the services provide those services in their slice of the marketplace. And these parties have gotten together without the benefit of any contract, and they're simply saying, the clients are saying, give it to me. I want your conventional services blockchain style. And the providers are running around creating a new way of doing business, but each for themselves. Each is doing their own proprietary IP development because it's only with respect to their slice of the market. So you can have proprietary technology that way, and you're the owner of your own technology. It's a different model, you know. And then you have, say, the R3 model, where it's a very large company and lots of owners, and they are owning their own platform. They've open sourced significant chunks of it, the infrastructure of it, but they've reserved the right to have proprietary things they're building around it. And then they're fomenting scores of projects. When you've got over 100 members, it's easy to have scores of projects. And so they're all focusing on little microcosms of things they want to do that those members have a business need to create a solution for. And it's go on and on and on and on.
Wow. Well, this is one of those conversations that makes me glad that I do what I do and not what you folks do. Because, this is a hornet's nest. I don't think there's an easy answer. I can give you the easy answer from the software developer's perspective and as a software team manager, et cetera, and as a software company. It's just, I'm going to just beat the same drum. You just got to thoroughly document everything you're doing. And I believe that if you had a lot of documentation established, I think it would really help you to have a preponderance of evidence. And I think it would probably be pretty winning if you had a preponderance of evidence that you really maintain meticulous records. I mean, who's going to look like the thief, the one that has the preponderance of evidence of their whole audit trail, or the ones that kind of just look like they got caught with their hand in the cookie jar, so.
Yeah, the one thing I can speak to is in the connection with source code escrow, in our contracts, we're always very careful to say they need to escrow not only the source code, but complete documentation, source code documentation necessary to maintain the code by a stranger. And we build that in contractually. Then you have lines of business, and they'll go and they'll license the code, and they'll put up a source code escrow, and you say, hey, has anybody looked at that stuff? Do you really, check it out? You ought to look at that stuff, and I just know that traditionally it turns out that the source code documentation for commercial code is often very scanty. And then what good is your escrow because you can't maintain it because you don't know where tab A fits into slot B?
That's a place that companies are very short on. Software development companies is their functional requirements documents and their specifications documents. It's really helpful. All I can say is the more documentation you have about how the software works, how it should function, what features it has, and all that stuff, it's really good from not only a legal perspective, but also from a technical perspective.
Let's turn to talking a little bit about the protection of front-end code. And David, first, can you just explain for some members of our audience that may not know, what's the distinction really between front-end code and back-end code?
Right. Well, people may be generally aware that this primarily came up with web-based software. With web-based software, you have some code that is sitting on the server that's running at the server. It's usually written in I won't even go there because there's so many different languages it could be written in, but it can often be written in things like C# or Java, let's say, but I'm sure I'm leaving out 100 other languages it could be in. And that code stays on the server of the owner. So it's not necessarily, it's still at risk from hacking, but it's not at risk from like the front-end code, because the front-end code is the code that gets delivered from the server to your web browser. So when you actually go to a website and you're running some piece of software, you may be aware that there's all this what's called JavaScript code, frequently it's JavaScript, that's running on your machine. And it's actually literally on the user's machine and it's running in their web browser. So now you have your intellectual property that now is pushed down to the user's computer. So right off the bat, that seems like, when you're looking at it from a trade secret perspective, it seems like it's not secret anymore because it's out there on the user's machine. Certainly then you have copyright. Well, now I guess from a legal perspective, you can still maintain your copyright because even though that software is now in somebody else's hands, it's still your copyrighted code, okay? So not necessarily an issue there. However, it provides access. So in case somebody does infringe your copyright, they now have had access to your front-end code. And you certainly are putting it physically in the hands of many more people than the back-end code, so you're much more at risk. So what we're experiencing in the software community is there's a real challenge, like what is the status of the, particularly with copyrights and trade secrets, what's the status of code that's been delivered to the user in the front end? So, and now JavaScript code, front-end code is typically, before it's packaged up for sending, it's usually mutilated or mutated in such a way that it's not readily accessible or readable by the recipient. The computer's browser still can execute it the same way as the original code, but you're receiving what's called either an obfuscated or a minified version, or both, of the code. And obfuscation and minification means that first of all, it shrinks it down. That's the minification part. It shrinks it down so it's much smaller of a package, so it gets transmitted to the user's computer much quicker and takes less bandwidth. But it's also been obfuscated, so you might have a variable name or a function name such as get client ID, but that has been obfuscated into just G. Literally, it can sometimes be a single letter, and then the other function is called E, and then there's another function called S. So truly, a user, even a sophisticated computer programmer, can look at this code and not really be able to make heads or tails of it. So there are cases where the owner of this code is asserting that they're maintaining the secrecy of their code because it's been obfuscated and minified. So it's still secret because the recipient can't really make heads or tails of it.
And I think there's really no good legal answer to the question of whether they've adequately maintained trade secret. I think that's something that the courts are starting to deal with now, and there haven't been any decisions saying whether that is or is not sufficient to keep something as a trade secret. But certainly that is an opportunity to think about the timing of when one would file their copyright registration, because while you might be giving up some secrecy, you can, when you file your copyright registration, you can certainly redact things that you think are very secret, as long as you explain to the Copyright Office why they're secret. You can maintain the secrecy of some parts of the computer source code if you want to do that. And then I think the analysis courts will do is, well, how easy is it to reverse engineer this, to actually acquire the code that was written from the obfuscation? So, Larry, can you talk a little bit about how you would address that kind of issue with the bank?
I guess, and I wouldn't make this specific to the bank. I would simply observe that there has been a significant tradition in the electronics business of casting circuit boards populated with components in epoxy so that you can't see what's in the circuit. And if somebody wants to hack into it to try to figure it out, they are taking affirmative, inappropriate action to try to steal your trade secrets. The fact that the owner of the trade secrets has gone to the trouble to try to prevent you from seeing it strikes me as the equivalent of a confidentiality agreement. I mean, you're taking steps to preserve the confidentiality of your trade secret. What else can you do? So I think obfuscation sounds to me like a reasonable, prudent thing to do if you want to maintain trade secret status.
If that's the legal test, what you're saying about putting epoxy on a hardware component, my opinion would be that obfuscation generally meets that same standard. Yeah.
Well, to be continued then.
Okay.
And we'll see what the courts say about that in those cases that are coming down the pike. So I want to thank everybody for your time in joining our seminar today, and thank you very much again for your time spent with us today.